Morning.
Good morning. Good morning, Your Honors. David Miller for the City of Hollywood. If there are two things that I would like to stress to this court today, they are these. Number one, that the trial court applied incorrect law in its analysis of contract impairment under Florida law and basically created a new test that needs to be corrected. And number two, that the trial court ignored binding precedent. And before I continue, I forgot to reserve 5 minutes for rebuttal, please.
Okay.
The trial court ignored binding precedent of this court in determining that the plaintiffs possessed a vested right to entry into the drop program that could be impaired. To the first point, the trial court stated a test for contract impairment, departed from that test, and essentially determined whether a compelling state interest existed by measuring that against the degree of impairment of the supposed rights of the plaintiffs. The trial court stated there was no money saved. The city didn't prove that there was money saved by impairing these alleged rights, which is factually inaccurate, and therefore there was no compelling state interest. The degree
I thought the finding was more that there were other things the city could have done to save the money than to have affected the drop rights of the employees.
And that indeed is a part of what I've called in the brief the least intrusive means test, alternately called reasonable alternative means test, which is cited throughout the cases in various forms. There is some variety of language used. In any case, what the trial court did was to borrow that kind of a concept from a later leg of the analysis, import it into the compelling state interest analysis where it did not belong, and reach a conclusion based on this incorrect analysis and never reached the least intrusive means.
So did the judge find there was a compelling state interest due to the financial crisis, but the error was in how it prioritized who should take the hit?
As I understand the judge's ruling, the trial court's ruling, it found there was no compelling state interest at all. Because
well, if there's no compelling state interest, why did the judge even go into the discussion about, you could have cut other areas? And
She shouldn't have. The trial court should not have gone into that discussion.
So your argument is really the judge made the mistake with the test, and the test is not compelling state interest, or it is compelling state?
The test is compelling state interest. If there is a compelling state interest, then you look to
and
whether...
you're saying on this record there was a compelling state interest?
Certainly the city was facing bankruptcy.
So if there's I just want to make sure I understand, because to be honest with you, this is a very confusing area of the law, the test that this is applied. So if once the test is there a compelling state interest, and if there is a compelling state interest, then you go to the next step, which is, okay, who gets hurt the most? Who takes the hit? Because you could clearly on this record there were other areas where the city could have gone and done other things instead of affecting employees' pensions.
The test, Your Honor, is a balancing test. If there is a compelling state interest, then there is a balancing test. And if you'll look at Scott v. Williams from the Supreme Court, which is the most recent explanation, you will see a reference to U.S. Trust versus New Jersey, which goes into the balancing test, whether there was something, a less severe impairment that could have been undertaken, sometimes referred to as alternate means or more reasonable means, also referencing Pomponio, and also referencing State v. JP. All of these cases deal either with contract impairment or with other fundamental rights, and the court has held, I believe in State v. JP, that any fundamental right is subject to strict scrutiny and subject to this least intrusive means test as a second leg in the case of contracts analysis. So the proper test would have been determine that the compelling state interest has been twice ruled on by PERC in this same factual scenario, was preserving the city from bankruptcy. Then the trial court should have proceeded to the second leg, which is what I'm calling least intrusive means or alternative reasonable means, and determined at that point whether there was some other possibility. Now, in discussing that, the court did discuss that in its sort of skewed way, importing it into the first prong of the test, and said, number one, there were no savings. Well, that's a factual error. That's against the clear weight of the evidence. Clear weight of the evidence because there was undisputed testimony that there was at least $200,000 in savings, and probably a comparable, as to only one plaintiff, and a comparable amount as to each of the other three plaintiffs. So there's undisputed testimony that there was $800,000.
Actually, that brings me to my next question, and you've kind of started going down that road, but I want to be specific. On this record, if we agreed with you, should we send this case back for the court to then go back and do the proper analysis, the least impact? Or on this record, are you suggesting that we can conclude that the city made the right decision?
On this record, you can reverse and conclude that the city made the right decision because the compelling state interest, the record is clear that the city was facing bankruptcy. The legal part of the analysis
That part,
is
I said if we agree with that part of the analysis, now we go to the next, the least intrusive. On this record, can we conclude that the city's decision vis-a-vis these appellees was the least restrictive? What the city did was least restrictive, or are we required to send the case back for the judge then to go through the proper analysis?
You can make that decision on this record for two reasons. Number one, the factual evidence, the undisputed factual evidence that I alluded to earlier. And number two, the fact that the trial court also erred legally in restricting, again, in the wrong place in the analysis, but restricting its view of the impairment that was imposed very narrowly to only these four plaintiffs. The compelling state interest was bankruptcy. That spanned a $38 million required savings. These are four individuals out of almost 1,300 that suffered some sort of reduction. Now, viewed from that perspective, and let me hasten to add that the city does not view this as a contracts impairment case at all. This case in the beginning should have gone to PERC, but I'll leave that aside. That's briefed. The city was dealing with a $38 million shortfall. It had bare weeks or months to solve this issue. It was looking for savings everywhere it could in the general fund, 75% of which is labor costs. It had to take from labor. In order to do that, it had to change the contracts, the collective bargaining agreements with the unions. It did so through statutory financial urgency. It wasn't merely a contract, which again the city contends doesn't exist, with these four plaintiffs. It was the contracts covering three separate bargaining units and close to 1,300 employees, maybe about 800 employees under contracts, which were altered through this financial urgency process. It wasn't just these four individuals. The court would have the
Wasn't
city.
there only a limited number of individuals that were affected by the decision? That is, those officers that were eligible for drop when the decision was made.
The people affected by the decision to change the drop entry date, which applied to all three of the pension plans, of which theirs is one, affected every single member of every single employee, every single member of those pension plans, with the exception of individuals who were already eligible for normal retirement, which has to be kept distinct from eligible to apply for drop. That brings me, so the court would have this laser-like focus in the midst of a $38 million shortfall to look at every single individual to determine, well, is this going to cost this person how much, and is there some other way that we can cost that person a little bit less? It's an absurd
Let me ask this though, because it sounds though that really is your fallback argument in terms of the compelling interest, because, and correct me if I'm wrong, the city is basically taking the unequivocal position that these four officers, for that matter, anybody similarly situated, simply do not have a vested right to enter the drop program at a future date.
That is absolutely right, Your Honor, and I will address that question quickly. I see my 5 minutes are going here. Drop is not capable of vesting. It can't become a vested right because up until the moment that you enter, not apply for, but enter drop, that drop entry can be defeated. You can quit. You can be transferred out of a position that's eligible for drop. You can be terminated. You can simply choose not to do it, whether you applied or not. Since it is capable of defeasance under the law, it cannot be a vested right. And I will, if I've adequately answered, I'll reserve the
Thank
rest.
you. Yeah, fair enough.
Good morning.
Morning.
I'm William Scher III, the Scher Law Firm, and appearing on behalf of the appellees in this case.
Let me ask if I can start.
Sure.
I'm really curious. I've pored over these briefs, and I'm really, I guess, trying to find if in fact these four appellees have a silver bullet. What is your silver bullet in terms of the issue about vesting drop? Where can you say, Judge? Let me point you to this case, this constitutional provision, this statute, because this says it right here that in fact my clients had a vested right to enter drop, and the city could not take it away.
Well, the Persis case is instructive because that deals with the issue of the right and the vested right to have the provisions of a drop plan applied. And in the Persis case, the court made its decision based on two factors. Number one, that the normal retirement date had been met, and number two, that there had been an application to enter the drop. And although the particular amendment at issue happened after those events, the court concluded that the amendment did not affect the plaintiff in that case. And the particular issue with respect to drop is at the end of the drop period, the employee is entitled to take out the money that has been invested during the period in which they were in drop. And he was not required to also sever his joint employment with the city council as well as the school board under the old provision. There was a new plan that came into effect after he had vested and after he had made the application for drop that changed the law that says you have to terminate all employment from all employers in order to get the...
But your clients aren't, the facts in your client's case is not, they hadn't applied for drop, right?
Well, two of them did. Two of them made application with albeit with retroactive dates that they will go in at a later time, but they made the election. And the fact that the Persis court cites two important cases, the Bean case and the O'Connell case. And in Bean, there was the issue of election plus meeting the normal requirements for benefits was present. And O'Connell, the only qualification was that the plaintiff in O'Connell had met the normal retirement date. And in both of those cases, they found that they had vested rights. So Persis is really on all fours with at least two of the four appellees here who not only were eligible for entry into the drop, but also made the election. Now, what Persis doesn't say is that is whether both are required or whether one or the other is sufficient. And I would submit that the fact that the Persis court cited both Bean and O'Connell shows that it's an either-or situation. Because again, in Bean, you had the plaintiffs who met the requirements for normal retirement and made an election. And in Bean, it was an election to designate a former spouse as a joint annuitant before the law had changed. And in O'Connell, it was the case simply turned on the fact that the employee had met the conditions of normal retirement before the change in the law. There was no election. So the fact that the court cites both of those And the fact that the plaintiff made both of those distinct arguments in Persis is evidence that we had the right, as of the time of qualification, to enter the drop, to have those rights preserved here.
But what about your opponent's suggestion that drop entry, though, is contingent and it's uncertain, and that it could be defeated, it might never occur, and thus, by definition, can't be a quote-unquote vested right?
Well, you have to look at what the promise was. And in this case, the promise was that if you meet certain conditions, the promise by the city, we will provide this opportunity to you, or whether you want to call it a benefit of employment, benefit of retirement, what have you. And this really goes back to the Stringer case that stands for the proposition that when an employee fully performs all that is required to be done under the terms of what the offer is, then it becomes vested. And it's really akin to a principle of unilateral contract law.
Why doesn't PERC have jurisdiction in this matter?
Because this is not an unfair labor practices case. This is a case that challenges the unconstitutionality of a particular ordinance.
But does the collective bargaining agreement incorporate by reference the rights to drop pension benefits?
That's what it stems from, but the fact that the city modified the collective bargaining agreement, whether they had the right to do so, is really not an issue. The city could have...
Why wouldn't that be an unfair labor practice?
Well, it could have been, but we didn't bring that, and probably maybe wouldn't have standing to bring that. This is usually brought by unions. But in any event, the city either could have had the right to declare financial urgency or may not to reopen the collective bargaining agreement. That didn't matter, because that doesn't immunize the city for whatever decisions it makes as a result of reopening and changing the terms. And that really brings us to the point that the fact that there may have been financial urgency does not basically allow the city to take action with impunity and just take whatever steps it wants to without regard to whether it is impairing the contract rights. If I could get back to Stringer for a second. So according to Stringer, you really got to look at what the conditions are in the particular ordinance, or what the promises were that the employer has made to the employee. And in this case, the provision of the ordinance, it's got a couple of important points. Number one, normal retirement date is defined simply as a member may retire on the day he or she attains age 50 or completes 22 years of creditable service. Number two, the access to the drop is defined as a member may enter into the drop on the day he or she attains 50 or completes 22 years of creditable service.
But didn't your clients not only decide to enter the drop before that deadline that was given by the city, but then dated it in the future?
Correct. And I think that's akin to what happened in Bean, for example. Bean was a case where the employee had designated a joint annuitant of an ex-wife. Now, that may or may not ever happen. And that's another point that I want to make about the contingent nature of all of these benefits. The fact that a benefit may or may not come to fruition really doesn't affect whether or not you have a right, if, as is the case here, the promise is that we are going to provide a mechanism for you to utilize if you meet certain conditions. And in this case, the only limitations in the ordinance before September 30th of 2011 were that the maximum period of participation in the drop for members who enter shall be either 8 years or 30 years of total service. So at the time that the plaintiffs in this case, underlying case,
They decided to drop before the September 30th deadline, so they accomplished that, but then they chose a date for entering drop subsequent to the
Correct.
September 30th deadline.
Two of the four did, but it's our position in this case that none of them had to, because under the terms of the promise that was made by the city, they had done all that was required to earn the right to enter the
You
drop.
mean they qualified?
They qualified because they promised.
Your argument basically is, look, if they've qualified, it's a vested right at that point. Even though they've done nothing to exercise the right, nothing can be changed at that point simply by virtue of their qualification. They don't have to take any affirmative action.
Yes, because if they have done everything
I gotta
that,
tell you, I got a tough one with, that's tough for me to swallow. I just, there's something not right about that.
but if you think of it in terms of the city has made things available and told its employees, if you meet certain conditions, we will give you the drop, or we will give you retirement, or we will give you a death benefit, whatever. But once the employee does all that is required to meet those conditions, which in this case is simply either reaching age 50.
Well, that's during the entire term of their employment. You got a brand-new employee, you've got a drop program. The employee works for a number of years and at some point is vested, and at some point then maybe down the line, but never says a word about drop, just by virtue of the fact the employee's been there and these different events trigger them to qualify. They don't have to exercise, you're saying that the municipality in this case is forever barred from changing it as to that employee?
If they've met all the conditions of requirement, and that's what there's a line of cases, again, beginning with Stringer, that say once the employee has met all of the conditions required under the terms, then they have a vested contract right to those provisions. And really this is, in terms of the future, whether you're going to use it or not, it's no different than if you had a situation where there's a disability benefit or like a joint annuitant that may or may not ever come into fruition, depending on if you outlive your spouse. Those are always going to be contingencies. But again, the fact of the matter is that they met the only conditions and the only limitations on the use of the drop in this ordinance before October 1st of 2011 were you can only stay in it 8 years or 30 years. So come October 1st, there was a new condition that was added that, by the way, you also have to use it or lose it by September 30 of 2011.
Let me ask this question. You allude to, and I think I got this by reading the briefs. I knew that the four officers were kind of like in different situations, and the statement you just made really made me feel compelled to ask this question. So obviously, two of the four officers here did not ever even elect to enter into drop before that deadline, but two did. Is that what you're saying?
Correct.
And the two that did, how have they been adversely affected, which then leads them to this court today?
Well, because the city did not acknowledge their entry into the drop and therefore continued to make salary reductions where they were not supposed to.
But why wouldn't they make salary reductions if in fact they had officially and admittedly entered into the drop program prior to the deadline?
The city does not recognize their applications because they had retroactive dates of entering.
These are the folks that did the retroactive dates.
Correct.
I got you.
Correct. If I could also turn to the issue of the standard, the cases that were relied upon by the city are cases where the government is taking action that affects contract between two private parties, where a government is taking an action which impairs its own contract. There is a specific test to be used, and that's the test that comes up first in Childs, and then was again applied by this court in the City of Hollywood versus the fire pension case. And under those circumstances, where the city is contending that the reason it has taken action to impair a contract in violation of the Florida Constitution is a lack of funds, then it has to prove that there was no other reasonable source of the funds in order to justify that very significant impairment. And so it is a distinct test, but it's really just an application of the test that was discussed in Scott, but under circumstances where the purported justification for the impairment is financial. So the city has to prove that if it says it didn't have the money and it had no alternative but to impair these rights, then the city has to necessarily show that, well, in fact, it didn't have any other reasonable source of the funds. And in this case, the evidence was overwhelming that the city did not meet that burden at all. You heard about this $200,000, but if you look at the record, you're going to see that, number one, the $200,000 is based on a projection of the drop savings that the employees would made. There was no testimony about what portion of that 200, if anything, the city would ever have to pay, because the city does not fund all of the pension cost. It's only a portion of it. But moreover, that testimony was based on an equivocal answer that, yes, it might have been. Well, might have been is not the standard for purposes of demonstrating competent evidence, and did not carry the day for that particular record.
So once you were able to convince the trial court that the change was unconstitutional, what benefits did your clients receive as a result?
Okay, and I see I'm out of time, so if I could finish this question. The benefits that the clients received as a result of this being declared unconstitutional is simply the city following the terms that were in effect at the time the plaintiffs vested, which meant the city has to stop deducting 8% of their salary, and the city had to pay the accumulated benefits that it had been withholding. Under the prior...
Okay, but let me ask you this then. If your clients dropped by September 30th, at least two of them, in order to comply with the change, they might have waited, well, in fact, they did, I guess, set dates out in the future. Would those have been the same dates they would have ordinarily dropped, or just dates that they chose?
No, they would have ordinarily dropped later, because if you drop before you reach the full 22 years of creditable service, it affects the amount of calculation for your pension for the rest of your life.
Believe me, we're all three aware of that.
Okay.
So, but my point is that would your clients have dropped on the dates into the future after September 30th had this never happened, or would they have chosen dates beyond that?
No, they did not alter their actual effective
What they
drop
intended to
dates.
do in the first place?
Correct.
Okay.
Two of them just made applications in attempt to the extent they were required to make an election, they attempted to do so to preserve their rights as best as possible. Thank you.
Thank you.
Let me very quickly address some of the points that I just heard. First, to distinguish Persis, there is language in Persis. It's a very short opinion, and I believe there are 4 spots in Persis where the court addresses why Mr. Persis was vested. In each place, the salient point is that he had entered the drop already. Yes, applied and entered, I think that's said twice. The salient point, he had entered, and that distinguishes it from this case. If an application to Harvard is the same as a diploma, then I'm a Harvard lawyer, which I'm not. I went to Stetson, and I'm proud of that.
So you applied and didn't get in, is that what
I applied to Harvard Law. They didn't take me,
Okay.
along with many, many others.
Well, apparently it worked out for you.
I hope so. I hope so. Thank you.
So you're basically saying that even though Persis uses that language, at the end, it's really when they entered drop?
It does not use that language at the end. At the very end, it refers to entry. There is one spot farther up.
Yes, but
that
they
says
say
applied and
something else
entered.
a little further up. Okay.
And entry into drop is in fact retirement. And Florida law is clear. Once you retire, then indeed they vest. Once you are eligible for retirement benefits vest. The city's argument is drop is not a retirement benefit. As this court has held, drop is an employment status. Drop is a promise that I'm going to terminate my employment by a certain period, and I already retired. And so up until the moment you actually enter drop, it's defeasible, as I discussed.
Am I right, though, I'm sorry to interrupt, I just want to make sure I understand the city's position. If Officer Jones had, in fact, entered into drop on September 29th, the day before, Officer Jones then could have and would have been eligible, and the city would have funded up to 5 years of drop.
I believe for these plaintiffs it was 8 years of drop.
8 years.
And yes, that is correct. And in fact, there was, it's not in the record, but there was an officer who was in exactly the same, similarly situated as Mr. Veen and the other one who applied early, and he did go ahead and drop, and he was permitted to drop. These plaintiffs, because they were eligible for normal retirement but had not yet retired, were grandfathered into all the retirement benefits, but drop is not a retirement benefit, so they were not grandfathered into that. We discussed whether this should be an unfair labor practice. In fact, all three unions brought unfair labor practice cases. Two of them proceeded through PERC and to the appellate courts, one here, one in the first DCA. There are ULP courses of action that were available to these plaintiffs. That's exactly where this should have been, because this is all stemming out of financial urgency, which is a part of the public
What
employees.
happened to those two cases?
One case was affirmed without opinion at the first DCA,
Saying it was not,
saying that was a challenge, an unfair labor practice challenge. So that was affirmed. The city won that at PERC. The first DCA PCA'd it.
so it said it was an unfair labor practice?
No, it was not. The city won.
Okay, the city, okay, I'm sorry.
And the other case, and that was the ULP brought by these plaintiffs' union. The other case was the fire case. It went to PERC. PERC held for the city. This court held that PERC applied an incorrect standard and remanded to PERC for further consideration. That's on appeal at the Supreme Court, which is considering the lead case, which is City of Miami, to determine, well, what is the right standard. That hasn't been decided yet. Very quickly, there was discussion of the Childs case and what is the proper standard. Childs case was about a public contract. So was the Scott case, which was decided 20-something years later. And Scott references Pomponio, which is a private sector case, and references U.S. Trust versus New Jersey, which was a public contracts case. And they all incorporate this idea of a multi-pronged test, including the least intrusive means test that this court, that the trial court misapplied.
Great. Okay, thank you, gentlemen. Okay, our next case is R.J. Reynolds versus Odom.